names of actual two MLAs there. That's how this phrase has occurred. Now, he cites all that. Then your lordship has these amendments to delete. The object is that defection is a per se doctrine. Defection becomes a per se doctrine because you give highest weight to maintain purity. Whereas your lordship is, with great respect, thinking of a very, very unique, extreme case. It will be academic, it won't happen in politics. Of everybody leaving, except the Chief Minister and the Speaker. Theoretically, it can happen. But well before that, everybody will leave, including the Speaker, or he will be removed, as Sibal said. So it doesn't really arise. It will not, it should not come into your lordship's analysis of how to deal with this Nawab issue. The object is that as long as even the majority or large number or small number, minority, split, anything goes, we bring it straight, because we have found from 85 till these amendments came that the split and so many other defenses were being used. So, therefore, it's a per se doctrine. In a per se doctrine is the fifth bullet. The speaker has to get only two things, Malas. Kindly note that. What does he have to get? Why? He has to get, Malas, any evidence of voluntarily giving up or voting or abstaining. They're the only two categories. Now, Malas, second is easy. There's a whip to be shown. You absented yourself or did not vote. The first one is, Malas, your lordship has interpreted in 10 judgments by conduct, by going to the governor, by being photographed on a podium with giving speeches with the opposition. All the judgments are there. So the speaker must act if the 10th schedule is a constitutional sin prevention. Your lordship cannot allow the other side to ask him, you can act, but you may be biased. May be biased. So that's my second point. My third point is, this alacrity point. And I'm not on the general point which your lordship asked, but on the particular point which both Chief Justice and Justice Narasimha asked, on the notice period. Your lordship said they may have some relevance to what is the notice period which the speaker gives. Now there, just for the record, your lordship asked that question. Just note down this and then I'll give your lordship. There are three judgments which are very important. Lordship, note down, then I'll give your lordship. One is Ravi Nayak. It's a division bench from Goa. The second judgment is Yedurappa, which is not in any compilation that I know of. Just note the citation, need not go to it. 2011, 7 SCC, page 1. Both of these, Ravi Nayak and Yedurappa, are division benches. Both are division benches. The judgment I'll take your lordships to, which covers these two, is Srimant Patil, which is 2020. Now note, two things before I read that last judgment only. Goa, which is Ravi Nayak, has a rule of 7 days. Goa has 7 days. Both the Karnataka judgments, Yedurappa and Srimant Patil, also have 7 days. So Karnataka rule is the same as Goa. The actual notice in Ravi Nayak was 2 days. So less than the rule prescribed. This has great relevance to both the Honorable Chief Justice query and Justice Narasimha's recollection on that, which is important. In Yedurappa, 3 days was given and Srimant Patil, 3 days was given. Again, the rule said 7 days. The nub of the matter is that in Srimant Patil, the 3-judge bench said that what is important is not just the text of the 7-day rule in the legislative rules. The legislative rule will not be mandatory and will not be dispositive. What matters is that because of the urgency and the constitutional sin involved, did he get an effective chance or not? If he gets an effective chance in 3 days or 2 days, it is enough. It's reasonable opportunity. This also sets a record straight because it is not as if Yedurappa is ruling. It has been distinguished and in fact, in that sense, not followed by a 3-judge bench. Kindly see this in the judgments compilation. Just the last one will suffice. This is all based on alacrity. 2 days, 3 days, urgency. Of course, even 10 days may not be effective. I'm traveling in Iceland and I get 8 days notice. I may not be able to. And I'm right there, I know everything is happening, then 2 days is enough also. So 109 it starts. The relevant is only 112, but let me just read 109. May I read?
Yes.
At page 1292. My lords have got it?
Yes.
The petitioners contend that the principles of natural justice were breached when the speaker provided for a 3-day notice in derogation of 7.3b of the Karnataka so-and-so rules, wherein a 7-day period is prescribed. On the contrary, the respondents have emphatically stressed on the fact that there was adequate opportunity given to the disqualified members to make out their case before the speaker. So look at the rival contentions. counting the days in a sterile manner, and the actual effectiveness of the opportunity or adequate opportunity given. That was the rival contention. Principle of natural justice can be reduced to the straitjacket formula. The yardstick of judging the compliance of natural justice depends on facts in each case. In Das, it is well established, then they quote Das first. This court in Kyoto held that Speaker decides the question as to disqualification, adjudicatory disposition. This view received further elaboration by this court in Ravi Nayak, an order of an authority exercising judicial or quasi-judicial functions, passed in violation of principle of natural justice, is procedurally ultra-vires, therefore suffers from a jurisdictional error. That is the reason why, in spite of the finality imparted to the decision of the Speaker Chairman by 6-1, such decision is subject to judicial review on the ground of non-compliance with the principle of natural justice. But while applying the principle of natural justice must be borne in mind, they are not immutable but flexible. They are not cast in a rigid mold, cannot be put in a legal straitjacket. Whether requirements of natural justice have been complied with or not has to be considered in the context of the facts and circumstances. At this point, the petitioners have placed reliance on Yedurappa. This is the rival view, and argued that in that case, this court had struck down the disqualification order solely on the basis of the fact that only 3 days' notice was given to the members. Now the 3-judge bench leans in favor of Ravi Nayak. However, it is relevant to point out that Ravi Nayak's case, a disqualification order wherein the Speaker had granted 2 days' notice to the members, was upheld. The question is therefore not the number of days that were given by the Speaker for answering the show cause, rather to see whether an effective opportunity of hearing was provided. This brings us to the point already reiterated and not a straitjacket formula. So, this is the overwhelming alacrity fed into all judgments of 10th schedule because of the overall object. And one last thing here about the alacrity. There is a judgment of your Lordship from Maharashtra, I believe. Jalmi from Maharashtra. Jalmi versus Speaker. 1993 to SCC 703. Give me the PDF page. There is no indication in Vrindavan Nayak 65 that the delay in raising the question of disqualification provides justification for refusing to decide the same. And the emphasis really is on a prompt decision by the competent authority on the question being raised, since it is not in the interest of the constituency which such a member represents to delay the decision. It's the other way around. One of my friends argued that the constituency will become vacant. On the other way around, the cloud should be decided this way or that way. This decision is an indication the authority competent to decide must act promptly in deciding the same. Once it is raised even by a citizen in order to prevent a disqualified member from representing the constituency after incurring disqualification subsequent to his election, so long the question remains a live issue during the tenure of the member. This is dealt with. This is on general promptness. I am not on the case today. It's on general promptness. Now, Malis, 2 more things that I have done. 2 more things that I have done. One is, Malis, I believe Mr. Marinder Singh read Shivraj Chauhan or Mr. Jethmalani. That I am not getting into, Malis. There are 2 delightful paras there which are directly in my favor. Shivraj Chauhan, which I had the privilege of arguing before a bench of which my Lord the Chief Justice was a member, was a reverse case on facts. But your Lordship accepts today's principle in the very para my learned friend has read. Can you turn to that for a minute? PDF 1390, para 80. The principle your Lordship accepts, but the converse set of facts, it applies in the reverse. Judges have given up their lunch, you can wait until later. Now, Malis.
We are not saying anything, yeah?
Well, I am replying to Mr. Marinder Singh, Malis. If your Lordship is gracious enough to give up your lunch, Malis, we can all wait for 5-7 minutes more, Malis. Don't keep on doing it. Malis, para 80 is what my learned friend read. I'll read only my 2 portions selectively, Malis. Placitum B to C and placitum E to F. Can you note that in the same para? Para 80.
Yes.
And kindly underline those lines. But when you focus on the line, it becomes clear, Malis, what is the... This is on the non-conflation, the core point that you must keep them apart. Code versus a separate part of the Constitution. I am reading from B, placitum. The holding of a trust vote operates in a distinct field from the issue as to whether one or more individual members of the Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of the 10th schedule. Holding a trust vote is necessary to ascertain whether the Council of Ministers, headed by the Chief Minister, has the confidence of the House. Then Your Lordship goes on, the continuous existence of that confidence is crucial. So that is one category Your Lordship says. Now see below, E placitum, 2 lines below E. Neither the Governor nor for that matter the Court can entrench upon the power of the Speaker. But the pendency of the proceedings before the Speaker cannot be a valid basis to not have the confidence of the House in the government determined by convening of a floor test. I'm not saying your lordship is dealing with this context, but your lordship schematically and conceptually separates the two categories. One is the floor of the house, the other is the 10th schedule.
Neither the governor nor
And just to end in a minute, that word sitting goes along with the word while. While was mentioned by him, sitting I had mentioned in my opening. 181 uses the crucial word sitting. Now, whereas in parliament or in assemblies, sitting is on that day, that moment. It's not session. It's not intercession. That's a separate word used. Or days when there are no sittings, which are intercession days. Sitting means an actual sitting of the house. So notified. When the attendance registers are open for the members to get their daily allowance of 1500 rupees. Therefore, that sitting word with while read together makes it crystal clear that the speaker is activated or disabled for that sitting when that removal will have relevance. While that removal in that sitting.
issues.
Can I give your lordships this one issue I have formulated, the core issue of conflating or not conflating. If your lordship would want, I can give a one-pager on the issues by today evening.
Certainly, you can give us one
But just
page.
take note of this and answer this also. There's a little contra judgment which has taken a different view. 2012 to SCC 708.
Just get it from here.
Could I just on facts?
No, your lordship, I have another
On
question.
that 21st issue of the letter not being pointed out, since I was there, could I just indicate, because that came in the rejoinder, just that and Nike, I'll take 2 minutes, if your lordship permit. Well, as far as Nike, which is now being cited in rejoinder,
708.
my learned friend is wrong, because Nike was a case where the MLAs went and met the governor.
Okay.
There were 4 videos taken. And after that, the court said that there are videos of you meeting the governor and withdrawing support, where is the question of more than 2 days notice. We are not talking about withdrawing support. We are talking about that you're no longer the leader within the party.
Anyway,
There's a faction which is in a majority within the party. So there's no defection. Secondly, my lords, on suppression, with great respect, my lord, my learned friend is not being right at all. 21st, firstly, no one said it in the opening, but let me point it out as an officer of the court. 21st of June, a notice is issued on page 49. On 22nd of June, a hard copy of the same notice is received, signed by 34 MLAs. My learned friend refers to an email of 24th of June, which is replied to by saying that this is from a unverified account and we are rejecting. And that very email reply of the speaker says, I've met Mr. Chaudhary, I've met Mr. Prabhu, and I'm satisfied with what they are doing. And my learned friend comes and says that we've suppressed. Dr. Dhawan, on behalf of the deputy speaker, was present in court. He pointed this out or attempted to bring this to the notice of the court to say that we have rejected it. And there the court said, Mr. Dhawan, 34 MLAs have signed it. And you are saying
All right, I think we'll try.
Let me end.
my learned friend talks about suppression.
That's all.
Let me now end, Balas.
Yes.
By one para of Jagjit Singh and one answer to my lord's query.
No, just have a look at it.
No, I must answer it. It'll take 2 minutes only because your lordship is rising. I don't want to take your lordship. Jagjit Singh case is very important. Just note it, Balas, in your lordship, same compilation at PDF. 1 second. At 866, actually 865 bottom and onto 866.
Jagjit Singh.
The same compilation is Jagjit Singh. It's a constitution bench. No, sorry, 3 judges. 3 judges.
Constitution bench.
1 minute. Jagjit Singh?
Is a constitution.
लिखा हुआ है बोला हुआ Rajendra Singh Rana.
Rajendra Singh.
No, my apologies. It's called Rajendra Singh Rana. That's a constitution bench. Rajendra Singh Rana, not Jagjit Singh. Rajendra Singh Rana. This para, just read, Balas. The lordship will turn to this 866 on the alacrity point which I was on. Just 2 minutes, I just finished.
No, we get the point. I mean, that's have a look,
No,
because for completion I have given you,
Yes.
not for you.
No, but
What is the page of Rajendra Singh Rana?
Before I answer-
What is the page?
Page 866, continuation of para 45.
Yesterday issue cited.
Yeah, it was cited, yes.
Correct. Now this part was not read perhaps. Just see
Para?
7 lines above para 46.
Para 45.
In para 45, 7 lines above para 46 at page 866.
Yes.
Considering that if the 13 members are found to be disqualified, their continuance in the assembly, even for a day, would be illegal and unconstitutional, and their office as ministers would also be illegal at least after the expiry of 6 months from the date of their taking charge, we think as a court is bound to protect the constitution and its values and the principle of democracy, basic feature, this court has to take a decision one way or the other on the question of disqualification
Right,
of the 39.
Thank you.